ऑब्वियसली जब कोई इंडिपेंडेंट जाने की सोच रहा होता है तो सबसे पहला सवाल आता है कि देखो भैया 6 महीने की तनख्वाह बचा के रखना, हो सकता है कुछ ना आए. What gave you that confidence that I'm going to have enough clients कि मुझे ये नहीं लगेगा, सेकंड थॉट्स नहीं आएंगे कि भाई मैं इंडिपेंडेंट हो रहा हूँ.
So there is no one way of getting a retainer, and I have to say it's a huge comfort knowing that X amount is coming. Because when you're running your own practice, one of the biggest things that you do is you have fixed costs. So that comfort really comes in with the retainers. I always tell this to everyone who I'm trying to hire or interview. A CV automatically gets rejected if there are typos on the CV. You're applying for a job, you had one job, which is to make a CV, and you somehow managed to mess that up. That is something that I just automatically rejected, regardless of who it has come from, what kind of candidate it is.
Hello and welcome to another episode of Law Varta's litigation series. Today we have Naman Joshi, who is a practicing lawyer in the High Court, Supreme Court and District Courts in Delhi. And today we'll learn from him इनके क्या challenges थे, कैसी journey रही litigation में, और आज जहाँ पर हैं वहाँ से litigation की दुनिया कैसी दिखती है. So hopefully you'll enjoy the conversation. Thank you, Naman, for joining us.
Most welcome.
And do you want to start off with just introducing where you are at the moment in the litigation world?
So I have now been practicing for about 10 years. In June I'll finish 10 years. So I have I've worked in a firm. I have then started my own independent office, gone from hiring my first junior to now running an office of about 5. So I'd say I'm somewhere in the intermediate stage of a litigation practice. Of course, there's a marathon and, there's a lot of years to, really build it. But that's roughly where I would say I am at this point.
Yeah, that's nice. So it's great to know that you started off at a firm and now you are at a point where you're running your own office and looking forward. So इसमें it's a interesting journey. And why did you choose this particular career trajectory कि मैं पहले firm में जाऊँगा? How did that decision come about?
Yeah, actually it was accidental because when I was in law school, I interned with Mr. Gopal Subramaniam, and as a happy accident, I was lucky. I got what you call a pre-placement offer essentially to go and work in his office. So I was very happy. I was skating through law school knowing that I have a job offer. The day I woke up after my graduation party, there was a big newspaper article which said that he is now going to become a Supreme Court judge.
I remember that.
So my PPO sort of disappeared. So then, of course, I spoke to him and I was like, I haven't really applied anywhere else and I haven't really done anything. So what do I do? So he, of course, said, look, you can always come and clerk with me. There is no problem. And, but I would recommend that since your interest is towards litigation, you want to build a practice, look at your other internships, etc. Speak to somebody. I can recommend you to a few seniors. Go work in active practice. Don't go the clerkship route. I was like, great. I had interned at Karanjawala back in 2013. I, had that. So I wrote to them. They were very happy somehow. They said, of course, please come in for an interview. I went, got hired. As it would turn out, the next day, Mr. Subramaniam dropped out of the race to become a Supreme Court judge. But by then, I had already accepted. It didn't feel right to, leave that. I again spoke to him and he said, look, my own daughters work in Karanjawala. It's an excellent firm. So, don't leave it. Stay there, spend 3-4 years there. You'll be set in terms of how the litigation environment works in Delhi. And that's exactly what I did then. I worked at Karanjawala for 3 years, literally to the date, and then went and set up my independent practice. So it was actually an accident.
How good was Karanjawala in terms of helping you set up your own practice?
I can't even put a number to it because it was invaluable. I got very lucky. I had an excellent boss. So my partner was Miss Meghna Mishra, who heads the High Court practice at Karanjawala. I had an excellent boss who was very happy giving me all potential opportunities of drafting, briefing senior advocates, even appearing in court, sometimes to the chagrin of slightly, some of the senior people in the firm, which of course gives you the confidence to, see how litigation plays out. Otherwise, in a lot of firms, you will see that at least for the first, year, maybe even 2 years, you have zero client-facing or senior-facing interaction, which can somehow lead to either burnout or you can lose interest. I've had some people who've come from the corporate side and joined my chamber, who were basically in the first 3 to 4 months, so happy that they were getting to go to court and meet senior advocates and talk to clients on phone themselves, almost to a point of being shocked. They were like, "Oh, you don't want to be on the call, or you will not come," which is very different from, say, a chamber setting or a firm setting, where juniors from the first day are essentially thrown into the deep end, and then you have to swim. So Karanjawala has been invaluable that ways in terms of helping me build my practice.
That is so nice. And do you feel that you also owe something to Karanjawala in terms of how you get your initial few clients?
Yeah.
In the sense that obviously जब कोई independent जाने की सोच रहा होता है तो सबसे पहला सवाल आता है कि क्योंकि डराते हैं ना लोग कि देखो भैया 6 महीने की तनख्वाह बचा के रखना, हो सकता है कुछ ना आए। तो उस 6 महीने में मतलब what gave you that confidence that I'm going to have enough clients कि मुझे ये नहीं लगेगा, second thoughts नहीं आएंगे कि भाई मैं independent हो रहा हूँ?
So this was also, of course I took a leap of faith. When I left Karanjawala, I was drawing a salary of about 60,000 a month. And I was living with my parents. I wasn't married. They bought me the car. I was filling the petrol. So essentially, I only needed to look at my expenses. My first thought was to go join a seniors chamber. That seemed like the logical choice. After a firm, let's go work with the senior for 2-3 years, save some money, and then eventually, start. I did apply to a few seniors. Mr. Diwan said he's full at that point. Akhil Sibbal said he's full at that time. All lovely seniors, all replied to my email, which was excellent. All replied to my phone calls, that was excellent. Another, weird, strange incident. I told Rajshekhar Rao about this, that I wanted a, job in a seniors chamber. He wasn't a senior advocate at that point in time. For some reason, he thought I did not mean him, and that I was looking at other opportunities, and he, recommended here and there, which I thought was that he didn't have a spot in his chamber. And ultimately, years later, when we spoke, he said, "But you said you wanted a senior advocate. I wasn't a senior advocate, but for all practical purposes, he was a senior advocate." So yeah, that didn't happen. So when in terms of funding, I had one client who had a retainer with me for $50,000. So I was roughly at my salary level, which is 60, which is what I was drawing. And like I said, Karanjawala has been so good to me. When I was leaving, when I was going independent, I told Mr. Ryan Karanjawala, and he said, "Okay, so the firm will also give you a retainer to do some of the existing ongoing matters that you're working on." And it was a nominal retainer. It was but it's the confidence that your existing boss shows in your ability, and that helped. And of course, then you need a place to sit because office is one of your biggest expenses. My now partner, Jasmeet, had already gone independent about 6-8 months prior to me. He'd already taken a place on rent in Jangpura, etc. Friend, colleague. So when I spoke to him, I told him, "Look, I'm going independent, but I'm just wondering, office, etc. These are some fixed expenses which you have to, take care of, right?" So he essentially told me, he said, "Look, I have a place. I have an extra room. And I only have one junior, but there is some new work coming in, which I'm not sure if it will be long term, but I don't want to add to a fixed cost, but you come on. I will also give you 20,000 rupees a month. You sit in my office, you do your own work, but help me out with this one client." It worked out very well for us, so that's really how. So I began essentially with 90 to begin with, which was above my 60 anyways. And then, touch wood, with God's grace, work has never, there's never been a lull. So I never had to, really dip into that 6-month kitty that I had built. I had built that 6-month kitty. Worst case, I'm young, I'll fail, I'll go back to a firm. I'll say, "Okay, it didn't work out, but try another day." But luckily it did. So yeah, that's how it worked.
So that's a wonderful story in the sense that you've essentially just taken 3 years before you took the leap. And I think that's less than most people that at least I know. And I think that's very good. And so since then, you said that it's great and you've had a good practice so far and there's never been a lull. What part of the practice, only because you mentioned that one of the first sources of money for you was a retainer.
Yeah.
What part of that first choice of going independent and then sustaining the initial practice is getting a retainer like that? And how important is it? And are there some good ways to get it? Because so many people have these questions about, bhai, retainer kahan se milte hain? And some people say network karo, some people say, yaar, pichle boss denge, aise hi milega. But what is your story, and how do you advise other people to sort of try and get these retainers?
See, there is no one solution. There is no silver bullet, for this. The way I got it, I can tell you how I got my first one. The firm Karanjawala had a client, large corporation, whose, GC was essentially related to the owners also in some ways. So they could afford the firm. They were very happy with the firm. They were with the firm. But, some extended cousin of the GC, etc., brother, had his own little business in the cable industry, like cable business. And they wanted somebody to represent them in the TDSAT, which is the Telecom Disputes Tribunal. But they, of course, couldn't afford the firm. They didn't want another big firm. So they were like, boss, we want somebody who can do our work, but fixed cost, because we are not a big business. So we will give you 50,000 rupees a month. Whatever comes in this, you manage. So I was like, okay, that works for me, because you're also not a big business. You have about 3-4 matters a month. Eventually, of course, those disputes escalated. Worst case, I think at some point I was doing about 10 appearances for them a month, which was also okay because you had that certainty of 50,000 coming in. This client continued with me about, I think, for about 2 years, until they finally sold their business to Jio and exited. So, it was a good, happy relationship that ended, amicably. But after that, I've, of course, gotten other retainers. Some I've gotten through, introductions made on account of family relations. My dad knows somebody, my mother knows somebody. They, I enter the door with that. And then, of course, you make your pitch. You show them, that I've done this, I'm in this tribunal, that court, these are my judgments. Yeah. They take a punt on you maybe with, one matter sometime. And most of the time, the client will send you one brief on which they already have some other lawyer working as sort of like a test evaluation. They'll see if your work is comparable or better than the other guy. Then they'll send something as a paid assignment. After that, they'll eventually have that conversation with you, which of course works better for them because now they want to fix their cost. So they'll say, okay, let's do a retainer. And you know how much you will get, we know how much we are giving, and this settles it. The third way of getting retainers, I think, is obviously with time in the market. Once people see your practice, clients will somehow even sometimes cold call you or reach you through some other lawyer or through some other friend, sometimes even through juniors, and say that this is our litigation portfolio. Can you sort of quote a lump sum amount or quote as a figure? Because I've seen in India people prefer that certainty. That idea of line item billing is probably only prevalent in large firms and with very large clients. Even sometimes large clients want like a lump sum quoted figure. So there is no one way of getting a retainer. And I have to say it's a huge comfort knowing that X amount is coming. Because when you're planning for your expenses, because when you're running your own practice, one of the biggest things that you do is you have fixed costs. You have rent, you have electricity, utility, whatever. You have your staff, your clerk. And there is a huge sense of responsibility towards those people because they're definitely worse off than you are. And they're depending on you. In some cases, these are people who are, out of their hometowns, who are working in Delhi with you, for whom, rent is due on first, or they're living in a PG situation. They don't pay on first, they will be evicted on second. So with that sense, that retainer, at least tells you that worst case, nothing happens this month. I will be able to take care of these people, right, and I can tell them next month that I'm out.
Right.
Yeah.
Right.
So, that comfort really comes in with the retainers.
That's really important. And the other thing is now that you've now sort of looking back, I think 7 years you've been independent now. So in these 7 years, which fora are you sort of handling, and where's most of your practice? What kind of work do you do?
So my practice began in the High Court when I was at Karanjawala because I was in the High Court team. I have naturally, therefore, practiced more in that forum because I spent 3 years with the firm in that forum. And then, of course, knew more people, knew more counsels, knew more clients in that forum, etc. So High Court continues to be my predominant forum of practice. Of course, like I said, when I first went independent, all my appearances were happening in the TDSAT because my retainer client was in the TD side. But yeah, the High Court, I think today if I had to give an allocation, I would say about 80% of my work is in the High Court.
In the High Court. And what kind of work is it mostly? What kind of matters do you do?
Primarily civil and corporate commercial work. Some white collar crime work comes along with the corporate clients that I have, on the SFIO side, on the ED side, which now I think has become a bouquet of, it's a problem that almost every corporate client is facing at some end or the other. But typically, I don't get to do, not like I don't want to do, but I don't get to do, say, proper criminal work, say a murder trial. I've never even touched it, by extension. So that's something that's missing in my practice.
And among all these areas of law, do you think that which areas you end up working in is also sort of influenced by your initial years at Karanjawala, or has it been sort of dissociated with it?
See, there is obviously an influence. And I think it's because of these, it's like an economic barrier thing, right? Because while I was working at Karanjawala, most of the clients were corporate houses. Of course, HNIs, people who could afford the firm. That being said, of course, the firm also maintains a very rich and diverse pro bono practice. But that being said, it had a particular bent of matters. So when I go independent, and because I've worked in all those kind of matters, it was easy to pitch myself as a lawyer who understood those matters, who could work in those kind of matters. And therefore, naturally, my clients also tended to be corporate houses, people with rich disputes with the government, IPR disputes with each other, property disputes between two HNIs, rich people in Delhi. So that's the kind of work that ultimately sort of gravitate to. That being said, over the years there is diversification. Today I do work for some of the clients that I wouldn't see at Karanjawala. So that kind of diversification happens, but I think it takes time, because the market does typecast you, it does pigeonhole you as somebody who's from one particular subset and therefore good in that particular subset. It's a little hard to break out.
Yeah, got it. And now that you've been 10 years into the profession, आपकी प्रैक्टिस जो है वो फाइलिंग कितनी है, अपीयरिंग, आर्ग्यूइंग कितनी है, and what are you looking at now going ahead?
So, young office, so filing is front and center. In terms of active files, if I had to give you a number, we have probably about 400 odd active files in the office right now, maybe more. But luckily for me, a lot of my clients, some of whom are retainer clients, do not want to engage counsels and are trusting me with their briefs. So on an average, I would say that about 2 to 3 times a day, I do get to argue and appear in court. Of course, high stakes matters require counsel, so we are also briefing counsels. Sometimes I'm second chair, but there is a lot of front-facing work, which of course is what gives you the confidence to eventually aspire towards a counsel practice. But of course, filing is right now front and center. 5 juniors, a lot of filing happening in the office.
And since you mentioned your juniors and other staff, and I'm sure you also take interns from time to time, one question that young lawyers and interns will have is that what would a Naman Joshi look at on my CV when I apply to his office, and what makes me get selected? What makes me stand out from the other applicants?
So, I actually have a very, I've never been able to interview a candidate. I've gotten CVs on WhatsApp, I've gotten CVs through LinkedIn, people have sent it, I personally find it very hard to gauge a person's ability just based on the CV. And most of the hires in my office have all been people who have essentially said, you come and work in my office, 2-month probation, I'm going to pay you, this is not free. In 2 months, you don't like me, I don't like you, we part ways. And it's worked out sometimes, it hasn't worked out sometimes. I don't ask questions on the law in the interview because honestly, if you were to ask me some of them, I may not know the answer. I don't remember Bare Act sections, etc., all of that. I know the first principle, I know where to look, I know how to apply it, which is roughly what I expect that person to have. I always tell this to everyone who, I'm trying to hire or interview is, I don't expect perfection, but please try to at least move towards it, which requires effort. So, you can't be lackadaisical, you can't be, I didn't think of it, I didn't see it. One of the pet peeves though is a CV automatically gets rejected if there are typos on the CV. Because that just shows that you are not very serious with, you're applying for a job, you had one job, which is to make a CV, and you somehow managed to mess that up. Yeah. So that is something that I just automatically rejected, regardless of who it has come from, what kind of candidate it is. Yeah. So that is a pet peeve, but otherwise there is no strict criterion. I have people from NLUs, I have people from non-NLUs. The non-NLUs are sometimes done better than NLUs. I had a huge, bias in my mind about private universities. But one of my juniors right now is from Jindal, and he is outperforming his years. He is a 2 PQE who is performing at a 5 PQE level.
Amazing.
So, there is no set formula. It really comes down to how you apply yourself.
Yeah. That's amazing. And tell us something about your office generally. Like you mentioned that one of your seniors from Karanjawala first invited you to sort of sit with him. What does your office look like now?
So the office is in some ways like a barrister's set in London. We have a name. It's called Chambers of Joshi and Singh. We have 2 independent people under it, which is me and my partner Jasmeet. Jasmeet is an AOR. In fact, now his wife has also cleared the AOR exam. She's also a lawyer in our office. And there are 2 independent streams of practice running. Our billing doesn't overlap. Our clients don't overlap really. We sort of run a loose conflict check before taking on a client to ensure that we are not against each other. But sometimes that has actually happened where we have been on the opposite sides and we fairly disclose to the client that boss, we sit in the same office. Not in the same matter, but just for the same client on 2 different matters. And so I have 5 juniors working under me. He has 5 working with him. We have clerks, we have paralegal staff, support staff in the office. And essentially it's a great model for somebody who is starting off, because we get to share the costs.
Right.
So our expenses get taken care of that ways. But our income and we get to eat what we kill. And he's of course about 5 years older than me, so his practice is about 2x of what mine is today, maybe even 3x. So at no point is there that lingering thought in your mind that I bought in more, but because we are partners I've had to give someone more. Nor is that complacency in my mind that okay, even if I don't do well enough, it's a firm, and if he's doing well, I'm doing well, he's doing well. So I think that structure works out well in this situation. Because we've seen a lot of our friends, colleagues in the profession try and establish a formal firm with like an allocation saying 50-50, 40-60, whatever. And in about a year and a half, 2 years, whatever, that discontent does creep in, because at the end of the day, everyone wants more money, right? And then there is this, oh, you didn't work as much this year, I brought in more clients, why should you get more money? And we've seen that play out at the larger scale, right? We've seen that with large firms that have imploded over that. So, that way, I think Jasmeet and I have been fortunate that the structure that we devised has sort of stood the test of time now over the last 6.5 years that it has been in place. And there has not been a single conflict. We have never had a fight in office about anything, because very clear demarcations. And because of that, there is a very familial setting, because my juniors can work with him, his can work with mine. If there is urgent work, I don't need to ask him to pull any of his people in. I use his clerk for filing, he uses mine. It's very fluid because it's very transparent.
No, that's fantastic. And just out of curiosity, how do your juniors get along with
Jasmeet's junior? Quite well, because see, again, there's also a personality difference, right? So Jasmeet is a more outgoing person. He is more likely to know who somebody is dating. They've had a breakup. They're down in the dumps right now. I am more about the work, and the rest is, do you need space? Great, take it. Do you need to go home? Go home. It's fine. You're not well, go home. Don't. Your mother's not well, please go home. But Jasmeet will have that extra question about what's wrong with your mother. So in some ways that sort of complements, because I can be the bad cop in the office. I can, be the most stern, talk about work, and just Meet is more fluid, loose. He'll, have a drink with them. He'll chit chat with them. Of course, I also go out drinking with them, and my rule is always 8 to 8. I'm your boss. After 8, you can bitch about me to me. It's all good. But yeah, so there is a big personality difference. So he actually gets along with most of my juniors very well. Has a independent personal equation with them, which in some ways I also have with his juniors, because I collaborate with them on work. So I've worked with some of his juniors directly on matters, engage them, professionally also to handle some stuff. So it works out well.
That's nice, because you'll have some idea about their competence, and they will have ideas about your temperament, etc., etc. That's quite nice. And a lot of queries that I got when I was starting the series was about office environments generally. You've been both a junior at a firm, and now you're sort of mentoring 5 juniors. What is your experience about bad traits and good traits that a boss can exhibit in terms of boosting the confidence of his juniors, and conversely damaging it?
See, I think it's a thin line between structure for good practice and structure for the sake of rigidity. For instance, a lot of bigger firms you will see have that. Be in the office at 9:30, you don't fingerprint in, it's off. Then you have to, whatever, you're working, you have that time logger in the back, you have to bill a certain number of hours. You cannot leave before 6:30, 7, whatever the time is. And it doesn't work like that. I think in those situations, you are essentially feeding dissatisfaction. Or at least if not dissatisfaction, some sort of discontent, rumbling inside, which ultimately I have seen over my experiences in about 2 to 2.5 years, 3 years, bubbles into a volcano, and the person ultimately resigns and says, I'm either going independent, I'm switching jobs, or I'm going to, now leave the law itself and go open a restaurant or something. Yeah. The way we've tried to do it, at least in our offices, we've always been very fluid about certain things, which is, as long as the work is done, in the timelines that are given to you, etc., you are free to work out your schedule the way you want to work it out. So, for instance, if I have to give you an example of like 2 different juniors, I have somebody who is a morning person who prefers to, do calls, notes in the morning at say 8:30, and everything comes in that early morning-ish window. And then there is somebody who sends stuff at say 1 in the night, 2 in the night, which both work out for me because they're within the timeline that they were given. Now, in some other offices, what you will see is that you will be told that 2 is not okay. You have to turn this at say 7 in the morning. And that is a person who is not comfortable with say morning, etc. Or the 7 guy is being told that this has to come at 7 p.m. in the evening, or at 9 p.m. in the evening, or we'll do this call at 11 in the evening, which I think doesn't work because, and again, that I think is rigidity. That is not structure. There's just rigidity because you are being rigid about the way you want things done. And there is really no right way of doing it. There are just different ways of doing it. So I have personally always found that to be extremely useful, giving people the freedom to make their own micro decisions, how they want to pace their schedule. For instance, there are days when we have 2 or 3 matters and the same junior may be marked on them. Now, I know which court I have to go to physically. I know which one I have to do by VC. And I have a little chat with them and we just sort of, strategize saying, okay, so I'll go here, you'll go there, and then we'll try and converge here. But if we don't, we see this is what happens. You take on their input, and sometimes you realize that actually their input may be more cogent because for whatever reasons, they have a better read of the situation. Sometimes actually it also comes down to, because they speak to the client on a regular basis,
right,
they can tell you that this is a particular client who is, right now feeling a little ignored. And he would prefer if you come physically here and do something else by VC. Which may sometimes not be my read because I haven't spoken to the client in say, week, 2 weeks. But the junior has been following up and he's informed into the matters tomorrow, etc. So again, collaboration, that helps. Micro, so yeah, I mean, of course, I have my pet peeves. For instance, formatting is a major, pet peeve with me. I can't tolerate it, so I will micro, point out that, why isn't this okay? Why isn't that okay? But in terms of just, say, legal arguments, for instance, there are 3 arguments to be made. They have been made in, say, A, B, C order. I may have made them B, C, A, but it doesn't really change. It's fine. So I will not reverse that. It's okay. Somebody has, worked on it. Somebody has applied their mind, and there is some logical flow there. So there is no disruption for the sake of disruption. And of course, there is. I mean, I learned it the hard way. Delegation is super critical. You cannot be everywhere all the time at once. It is not possible humanly. Jasmeet, of course, I mean, is older, so I guess he mastered it before me. Today, he, I think, has managed to delegate about 90% of his functions to his team, and is therefore able to focus on the critical functions of, say, business development and counsel practice, which is arguing the matter. I think even now have managed to only delegate about 70% of my functions. I will still sometimes pick up a draft, and maybe, I don't know, it's nostalgia, maybe sometimes I want to, but I will still sometimes pick up a draft and just for the heck of it, draft it myself. Instead of delegating it, knowing fully well that if I do delegate it, it will be done, immaculately. It will be, done by somebody with full responsibility. But there is that, if I do it, it might be better. So yeah, but hopefully I'm able to get through that and delegate more with time, because that really is the only key. So essentially, delegation, structure but not for rigidity, allowing people to make their own micro decisions and sometimes even macro decisions on a larger scale. During the vacations, I sometimes just leave instructions saying A and B juniors are in charge. Anything, you talk to them. If they think they need to escalate it to me, they can call me. Otherwise, just don't bother me. It's okay. And yeah, that seems to work out pretty well.
That's quite nice, and I think the fact that you repose this faith in your juniors will also give them a lot of confidence. As you mentioned about your experience in Karanjawala.
I'm just paying it forward.
Yeah,
I've had great bosses.
Yeah, and just one follow-up from what you mentioned about scheduling conferences, for example.
Yeah.
That is one aspect which I think will necessarily involve a conflict at some point between your preferences about the time of the day you want conferences and maybe your colleagues' preferences. And how does that usually work out? Are you able to sort of say, okay, this colleague wants a conference in the evening and I'm happy to do it in the evening, and other conferences I'm happy to have in the morning? Oh, how does that work?
So, see, I mean, it really is a hierarchy, right? So if there is a senior advocate on the matter, well, their preference is the only one that counts. If there is a client and their GC is involved, their preference counts. And then, of course, we all have to, accommodate. But if it's an internal discussion, etc., I am quite happy to accommodate, because given that I may have, say, 5 or 7 matters in a day and there are, different juniors, I can always work on 3 or 4 in the evening and do 2 in the morning. So as far as I am concerned, I am fairly flexible. Of course, there are days when I have my inflexibility because, I may have personal engagements, I have a party to go to at night, I may not wake up early in the morning. So, of course, that is there. But then so essentially when you are adjusting, even people on the other side are equally happy to adjust and there is no resistance. So conferences sometimes happen on WhatsApp calls, they sometimes happen on Zoom calls, sometimes they'll just be, half an hour earlier in court, and you're able to, work your way around it.
Yeah, that's nice. And now I'll just come to the last major topic that I want to discuss, which is appearing in court, engaging with judges. What are some, maybe something comes immediately to your mind. What are things that you see some juniors do, which you would, if you were in a position to advise them, you'd say, don't do that. There's something you can do better about this.
I mean, see, apart from the usual suggestions of preparation, etc., which, to be fair, I have seen, at least in my experience, at least in the Delhi High Court, in the Supreme Court these days, younger counsels are better prepared. There is a sense of responsibility. They have more or less, let's say, not always, but I would want to say more often than not, read the file, are aware of the brief. They may be underconfident, but they actually have the information within them. And sometimes you'll see actually judges probe them and they will give the answer upon being probed. But what I do sometimes see is, which I think over time, you grow out of and you learn not to do. One is talking over each other. Yes, it may be an effective strategy at one point. You think you can distract the judge by, interrupting the other counsel from making the point they're making. Perhaps you may be even successful in derailing them. They may not have the confidence, they may not have the, flow and structure to go over it. I don't think it really works. Especially, at least in my experience, I've seen this in Delhi High Court. Most of the judges have read the files. They know what's happening. So even if you somehow manage to stall the other side, you're not really going to get a convincing, you're not going to convince the judge. That being said, it also causes a negative effect because, you seem overeager to, sort of stop the other person from making their point, which I don't think works in the long run. And if you'll see some of the, of course, there are counsels on both sides, some of the senior advocates on both sides. But if you see some of the, leading names, just say in the High Court or even in the Supreme Court, there is a lot of grace in the way they argue a matter, even in highly contentious situations. And there is always this, courtesy, accommodation that, whatever happens in court is fine, but, outside we're all good. I do see a lot of young counsel get very passionately involved in the matter and sort of carry it outside court, which again I think is something that with time will go away because you'll realize that you can't have 1,000 enemies. Yeah. You can have one or two, but you can't have 1,000 people that you're angry with all the time. So yeah, that's one of the other things. Drafting is, that's something that I really want to flag. A lot of juniors, perhaps because of the chambers that they worked in, perhaps the offices that they worked in, carry this sense that everything is won or lost in the oral arguments. I don't think so. I have actually firmly always believed that about 70 to 80% of the war is won or lost in your pleadings. And that is actually why we see so many people suffer at the appellate stages, because the client or the counsel has not, really looked at the trial, looked at the first filing. There's something missing. And then you can keep, of course, improving. There is law on both sides in India, so you're able to pull some precedent or the other, saying I can improve, I can do this, I can add, I can amend. But that cycle does not lead to a positive verdict, at least not as fast as it should otherwise. And drafting is something that a lot of people give a go-by to. They're like, oh, it doesn't matter if I haven't said it, I can always amend it, I can add it, I can carry it to court. Why should I cite the judgment in my pleading? Why should I give advance notice to the other side? So I think that doesn't work out really well, because if you do your work on the first day, then that work stays with you till your last day when you're arguing the matter. So if the way I draft something is, my pleading is comprehensive because I cite my judgments in it. In my, say for instance, I'm doing an appeal, I will mention the judgments I want to cite. And now because e-filing, it becomes easier for the judge. So I annex it also. So, I don't have to do a separate judgment compilation. And you can screenshot it in there. Yeah. And at the end of the day, there's a human being on the other side, right? So if you make their job easier for them, they are more likely to swing your way in a 49-51 situation. So it's those little things that really, and of course, I've also over time learned these things. For instance, like I would never, in a pleading, I always thought it was not okay to put certain parts in bold, because why should I divert, that was my feeling, that why am I diverting focus from the rest of my pleadings by saying this is more important. Everything is important, you should read the whole thing. And over the years I realized it is impossible, because the judge has 60 matters in a day. He cannot read everything, it is not right. And so, I've done a lot of work with Vijay Agarwal, who's like a major criminal lawyer. And he told me this, he said, if you cannot convince somebody to just see the bold portions, you cannot convince them to read any of the other portions. So if you have a salient point, you must put it either in the synopsis and put it in bold, or in the first 2-3 paragraphs of your appeal saying, this is the order, my problem is with these 2 lines because A, B, C and D. Right. And he said, if the judge likes that, he may actually read the rest of it, or in his notes say, hear more in the oral arguments. Let's see what they say. But if it's all bland text and, there's likelihood that nobody is reading it. So these are those little things I think that you can pick up earlier in your career, I think, to, sort of leapfrog some of the years of the hard work.
Yeah, my former boss used to say that the Supreme Court, every single synopsis starts off with that same dry sentence.
Yeah.
This SLP arises out of impugned or dated. So I said, if you want the judge to catch attention in the first, don't start with that sentence. Just say impugned order falls because of two reasons, like what you said, A and B. But that's excellent advice. And just as a last sort of observation that you had, because of your career trajectory, which is not really focused on the traditional, I'll first go to the trial court, then High Court and Supreme Court. What is your view about this trajectory? Is it essential? What is this? What do you make of the traditional wisdom that if you haven't been to the trial court, you haven't done real law?
See, I think it's each to his own. Like I said, my journey in the High Court also was an accident. I would have ended up with a Supreme Court lawyer. Mr. Subramaniam didn't practice anywhere else. He was a pure Supreme Court lawyer. So I actually would have seen 0 trials in my life. I would have been doing pure appellate work at least for the 2-3 years of my first year of my life. Luckily, unluckily, luckily, accident, happy chance, I ended up at Karanjawala, where because the Delhi High Court also has original jurisdiction, so you have some tangential exposure to trial practice also. That being said, you also end up sometimes going to district courts because Delhi also has a unique pecuniary jurisdiction situation. 2 crores is still not enough. Your real estate disputes may go here, there, IPR may go here, there. So you have that exposure. That being said, is trial experience important? Of course it's important. There is no doubt, because those parts of your practice you cannot gain in any other part of your practice. For instance, you will never cross-examine in any other situation. If you will not cross-examine, you will not know how to really incisively glean information from a witness, which may help you in your, defense or in your, prosecution. Little things like what is the difference between an exhibit and a mark. Nobody will teach you that, because when somebody is working with you, they assume that you know this, but because you've never done a trial, you may not know this. So I've had, like I told you, I've had juniors who've come from corporate firms. They've started at a national law school for 5 years. They never interned at a trial court. They worked with, law firms. They worked with senior counsels. Then they went to a law firm, top tier. Then they came back to private practice. Now they're working with me. Now I may have a trial in the High Court or in the trial court, and I, tell them that you have to mark exhibits. Now they're completely blank at this point because they don't know what marking of exhibit is. Now this is not taught in any book. So these little nuances, I think you can only pick up in a trial environment.
Yeah.
And because of the way trials are conducted in India and they're so unique, honestly, if you were to even write a book, you couldn't write a book about it. Because there are also these particular local idiosyncrasies about, how the documents are volumized in the trial, what is the question, what is the suggestion, how do you put it. Some judges are okay with it, some are not okay with it. Some just say put one suggestion in the end saying, I put it to you that you have deposed falsely. And once he says no to that, everything is answered. Yeah. So those little things I think you pick up while you're working in the trial court. Some part of your internship I think you should at some point do in the trial court. And that way I think these national law schools have it good, because they do structure it like that. They say you go intern at a think tank once, and then a trial court, and then a high court. So I would ideally say you should do that. Yeah, you should do that.
So that's great. Thank you so much, Naman, for this conversation, and hope you all enjoyed the conversation. Please do like and share the video. Subscribe to the channel and do leave a comment about what are some other questions that we've been missing so far, and we can ask our future guests, and we promise that we'll take it up. Thank you so much.